promise to be good stewards of your time. This evening is on special needs trusts, and I believe we'll reinforce some things that many of you may already know, but I'm pretty confident we're going to move into some territory that most all of you are less familiar with. And so I hope by the time the evening is done, it's not a worn out subject that we beat up a little more, but actually enhanced and grew your knowledge and understanding of special needs trusts. I often say special needs trusts are as close as a special needs community as we will come to having our cake and eat it too. It's just almost unbelievable that legislation was passed and that we got the gift of using this incredible tool. And what a tool it is, as you'll see as we proceed this evening. Okay. So special needs trust providing for lifetime care and quality of life. Last week we had two separate PowerPoint presentations. This evening we have a single PowerPoint presentation, and I will be doing some of these slides, and then I'll yield to Matt, who'll take over and do some, and we'll do just a little bit of back and forth, but not too often. We hammered that out earlier today. Okay, important disclosure. We're not, again, all things to all people, though we try hard. And in as much as corporate or trust companies or non-individual trustee options will be mentioned as a part of the presentation, MassMutual Trust Company is a federal savings bank, and appropriate disclosure in that regard. Special care has been mentioned a couple of times, but again, it's a program developed by MassMutual that provides access to information and resources to families with dependents of any age who have a disability. The mission is to help educate families and caregivers of people with special needs about the importance and steps in creating a life care plan to help provide a secure financial future. And of course, I'm a special care planner, and that provides me the opportunity to help a lot of families and to work with wonderful attorneys like Matt that's with us this evening. We have specialized training with special needs and life care planning, and we obviously work hard to show integrity and value the relationships that we have. A professional associate with knowledge and years of collective experience, and the focus is on you, your loved ones, and your entire family. So there are 10 comprehensive life care planning steps addressing primary issues, creating a vision, guardianship, which we have talked about. In fact, last week we focused on guardianship and ABLE accounts, identifying financial resources, preparing life care plan costs, preparing a letter of intent, and legal instruments. Letter of intent will be included in next week's workshop. Legal instruments, which we covered, actually we'll be covering some of that this evening. And then review need of special needs trusts and ABLE accounts last week. Tonight, special needs trusts, hold family meeting and review. So some reasons to create a special needs trust. If they're that good, then who needs one, or why do we set one up? And these are just a sampling of some of the reasons why a person might need or benefit from creating a special needs trust. So developmental disabilities, so developmental or intellectual disabilities would be a reason. Congenital disabilities, that is a condition or diagnosis that came about from birth. TBI or traumatic brain injury or spinal cord injury. Medical malpractice situations where someone was affected by a medical situation that did not work out well. That can be at birth, or it can be along the way in someone's journey. Personal injury meaning from an auto accident or a fall, or a situation where injury was sustained, usually of an accidental nature. Manufacturer liability, such as automotive or a crib situation, or there's just a wide variety of manufacturer liability where a liability is created, litigation, eventually a settlement. And speaking of that, structured settlements are typically settlements where there's a series of payments made to an individual that has been harmed or injured as a result of an event. Inheritance can certainly be cause for setting up a special needs trust. Receiving a gift or the interest on someone's part in making a gift. And then government benefits. And we have talked about this. In fact, workshop number 1 was an in-depth review of government benefits, but Medicaid and or SSI eligibility issues related to income or resources. So again, lots of reasons for considering a special needs trust. We've got government, a little bit on government benefits, and Matt, if you want to help out with this, if you would.
Yep. So kind of before we get started on special needs trusts, just a little small review from week 1 when we talked about government benefits. As you may recall, there are 2 types of government benefits. The first type is non-means tested or pension or insurance type benefits as listed in number 1 in the slide. And then the second type is means tested or needs based benefits as listed in number 2. So to the first type of benefits, pension or insurance type, remember eligibility is based on some factor other than need. So for SSDI, Social Security Disability Insurance, eligibility is based on a qualifying work record. For Medicare, eligibility is based on age and or disability. So the benefits are based on contributions into the program. They're not based on the person's financial needs, not based on income, not based on assets or resources. Contrast that with the second type, the needs-based benefits, where it is based on need. So you look at what the individual has, how much money they're making, and how many assets they have or resources is the term that's used. So for example, SSI, supplemental security income, or Medicaid. So an important point, specifically for the resource requirement, this is where special needs trusts really come into play because they allow money or assets to be set aside for an individual with special needs without being counted as a resource. So we'll touch on that more, but making that connection from week 1 to this week and how the public benefits, the needs-based public benefits connect with the special needs trust. So some items to remember as we go through. The first is that individuals with special needs who either qualify now or already, when qualified, they're already receiving Medicaid and SSI, so those need-based benefits, can't continue to receive those benefits if they have more than $2,000 in resources. So as an example, if they had a bank account in their name and they had over $2,000, that would render them ineligible. So a strategy to get around this $2,000 resource requirement is to place those assets into a special needs trust. And this can include inheritance, gifts, life insurance proceeds, retirement accounts, the list goes on and on. And again, the items that are in the trust don't count as resources. That's the real benefit from the special needs trust, assuming the trust is carefully drafted. More on that in a moment. But that's the real benefit. They don't count. And so a strategy to get around that $2,000 number, we put them in the trust. It's important to remember that the special needs trust assets are designed to supplement the benefits that the individual with special needs is receiving. You'll hear the term supplement and not supplant several times throughout this evening. That's an important takeaway. So any of the trust assets, when they're distributed for the beneficiary's benefit, they should only be used to supplement the benefits that they're receiving. and they shouldn't supplant them. We'll discuss in more detail in a moment what that actually means. And then last point, you should definitely work with an attorney and a financial advisor such as Gordon, that's familiar with this area, because as an example, not a personal story, but there was litigation involving an attorney that practiced in this area, and they actually had litigation involving a special needs trust, and the litigation focused on the word and versus or. So it can be very, very detailed, and very, very picky. So that just shows you have to have someone that understands what they're doing in this area, because just a very, very small difference or error in the trust can lead to big problems. So keep that in mind. So moving on to OBRA 93, that stands for the Omnibus Budget Reconciliation Act of 1993. That is a key law that helped pave the way for where we are today when it comes to special needs trusts. So OBRA 93 basically overhauled Medicaid and authorized parents, grandparents, guardians, and the court to create special needs trust for individuals who were considered disabled under Social Security. Prior to OBRA 93, in order to qualify, for example, Medicaid, in order to qualify, you had to spend down, you had to spend your money, use it in some way in order to qualify. So OBRA 93 basically created the special needs trust concept, and we've been building off that ever since. So under the Medicaid rules, there are limits on the ability of an individual to transfer their own assets to other people in order to qualify for Medicaid. So it's important to remember when we're talking about the special needs trust context, we're often operating under an exception to the general rule. The general rule for Medicaid is that you can't transfer assets for less than fair market value in order to qualify for Medicaid. So if I had a house and I wanted to qualify for Medicaid, I couldn't just give my house to my neighbor or to a friend in order to qualify. That would be an invalid transfer, and there would be a transfer penalty invoked. So that's the general rule. An exception involves the special needs trust area, where an individual, if they meet the definition of disability and the trust meets the trust requirements, they can transfer assets to the special needs trust, and it can be a valid transfer. So again, an exception to the rule, as it's listed here, a Medicaid payback trust is an example. We're going to go into more detail as we go. So just keep that in mind. We're operating under exception to the rule, reinforces that we need to be calling on professionals that are familiar with this area, because again, if we're not following the rules, we're under an exception that are very detailed. We can easily fall back to that general rule that is can create big problems for us. So what is the special needs trust? I guess the basic definition is that it's an estate planning tool that allows money or assets to be set aside for the benefit of someone with special needs without jeopardizing their eligibility for needs-based benefits. So Medicaid, SSI, Section 8 housing, Medicaid waivers, all those items. So a special needs trust is a means of enhancing an individual's quality of life beyond what's being covered by government benefits. So food, shelter, and healthcare. So SSI covers food and shelter. Medicaid obviously covers healthcare. But there are many needs beyond just these items. So the special needs trust can really be helpful to cover the individual's needs outside of these food, shelter, and healthcare expenses, because obviously there's going to be needs that don't fall into one of those three categories. That's really where the special needs trust can be helpful to the individual, can increase their quality of life, because government benefits only can do so much. They can only provide so much. So special needs trust distributions, to the second bullet point, just remember it's pretty broad in terms of what the trust can be used for. So it can be set up to pay for camps for the individual to go to, take vacations, travel, buy sports equipment, pay for education, job training. It could potentially even cover costs for medical equipment or services that aren't being provided, again, supplementing benefits. So if Medicaid or potentially Medicare will cover those items, then that's first looked at. So items that aren't otherwise covered. So dental care, it could potentially purchase a house or a condo for the trust beneficiary to live in, furniture, clothing, personal items, entertainment, the list goes on and on. Um, if the trust is properly drafted, again, the proceeds placed in the trust don't affect the individual's eligibility because they're not considered available to the trust beneficiary. That's the real value of the special needs trust. And then just a practical point, the funds in the special needs trust are typically invested for growth and income so that over an annual period of time, the trust is growing, the proceeds are growing, so there more money available to the trust beneficiary, and that also the funds will last longer. So who should establish a special needs trust? I like to look at this in two categories. The first category is parents or other family members of an individual with special needs who want to leave something to that loved one with special needs, either immediately or when they pass away. So when mom or dad pass away, for example, that's the first category of folks that should establish a special needs trust. The second category is individuals with special needs who have excess income and or resources, and they want to either qualify or continue their qualification if they're already receiving benefits such as Medicaid and SSI. So those are the two broad categories of folks that should establish a special needs trust. Now, each of those, you'll learn in a moment, will trigger a different type of special needs trust, but more on that in a minute. So um, a caregiver or donor can establish a third-party special needs trust for a child, sibling, or a loved one who is disabled. Again, that kind of goes to that first point, parents, loved ones, establishing for a loved one for their benefit, they want to leave something to them. A couple of questions that often come up that lead to the creation of a special needs trust are who's going to take care of the loved one with special needs when I'm gone, or for example, if I was the parent, when I'm gone, who's going to take care of them, or how can I leave assets to that loved one without jeopardizing their government benefits. So if you're asking one of those two questions or both of those questions, a special needs trust is probably right for you. So um, so again, a special needs trust, they, in terms of the process of establishing it, we first want to coordinate the available resources. We want to evaluate what the individual with special needs has, what income sources they have, if they have any at all, are they working, things of that nature. The idea is that that will help to ensure the continuation of their government benefits. Of course, the special needs trust will then provide supplemental needs for that beneficiary's lifetime and hopefully improve their quality of life. In terms of the direct distributions, we'll get to that more in a moment when we talk about the types of special needs trusts. So just a second on that one. So getting into a little bit more detail on how special needs trusts work. So first, the trust will stipulate how the trust funds, the money that are contributed to the trust, are used. And again, this is typically very broadly defined. It's generally left to the trustee's sole discretion. Think of the trustee as having the purse strings, they're in charge. They get to choose how the trust is used and how much money is used and what they're used for. So they have the ultimate discretion in terms of distributions, very broadly defined in what they can use the trust for, assuming it's for the trust beneficiary and it's for enhancing their life and their overall quality of life. So those are the only two caveats there. So The trust will include any state-specific language if necessary so that the trust is valid under state law. And then an important point, the trust will also name a trustee who is responsible for carrying out the terms of the trust. So naming a trustee is arguably the most important decision in the special needs planning process because the trustee will have broad authority, as I said, over the trust assets and how the trust assets are used for the beneficiary. So just know that naming a trustee is the first and often most important step in our process. And Gordon's going to touch on this more and what options are out there for the trustee in terms of naming one. But just keep that in mind. Trustee, very important role, is often, sometimes can be a barrier for families to get started because they don't have anybody or can't think of anyone. And that's where we can come in to help and to get some ideas floating out there. So the trustee is obligated to act both in accordance with the trust provisions, and they have to do what's in the best interest of the trust beneficiary because they're in a fiduciary relationship. What that means is that they're in a relationship of trust. So just as we were talking about last week with the guardianship context, that's a legal relationship. It has legal duties and responsibilities. The trustee is the same way. They have legal duties and responsibilities. If they're not following what they're supposed to do, there could be legal liabilities that attach. So keep that in mind. And then, of course, the trust can be created to fit the needs of the family, depending on what they are. So moving to the types of special needs trusts, the important point to remember here is there are two main types. Excuse me just a second. First party and then third party. Those are for our purposes, the key takeaway, two main types, first party, third party. So here, the first party is sometimes described in several ways. It can also be called a self-settled special needs trust. It can also be called a Medicaid payback trust. So there are several terms that describe the same thing. The Special Needs Trust Fairness Act we'll talk about in a moment. And then the third party trust, of course, is that other key type of special needs trust for our purposes. There are also pooled special needs trusts, which can be either first party or third party, which we'll get into. And then Miller trusts are kind of a special type of trust, but they're a little more specific in their applicability and they don't come up as often, but we will touch on those later on. So when we're talking about our two main types of special needs trust, first party versus third party, there are two main differences that I want you to keep in mind. The first difference is whose money is funding the trust, and second, where does the money go when the trust beneficiary passes away? So keep those in mind as we're going through. So we're going to start with the first party or self-settled or Medicaid payback trust, depending on how you hear it defined. So self-settled special needs trust is funded with money from the individual with special needs. So this is that first main difference, whose money funds the trust. In this context, it's the individual with special needs. And it's done so that they can maintain their eligibility. They can remain under that $2,000 resource requirement. So examples of where this come up, personal injury settlements is a common reason why these trusts have to be created. Another instance is unplanned inheritances where a family member has listed the disabled beneficiary as their heir under their will, for example, or left them money. That could be an instance. Or if mom or dad failed to plan and their son or daughter with special needs will then be treated just like their other children. Under the law, there's no distinction, disabled versus non-disabled, so they'll be entitled to receive a portion of the parent's estate that will often or almost always be over $2,000. So that could be another triggering event for the first party special needs trust. So back to the Special Needs Trust Fairness Act. In 2016, it allowed a competent trust beneficiary, a competent individual with special needs, to also establish a first party special needs trust. you'll recall when we were talking about OBRA 93, it allowed parents, grandparents, the court, or a guardian to establish these trusts. The Special Needs Trust Fairness Act added a competent trust beneficiary to that list. So a key addition there. The beneficiary has to meet the definition of disability. That makes sense, and that will apply no matter what type of trust we're talking about. For the first party special needs trust, they have to be irrevocable. What that means is that they can't be terminated. So think of the trust once it's signed as its own entity, it's out there. It can't be taken away. It's always going to be out there. There's no taking it back. And the beneficiary has to be under 65 in order to establish the trust. So we've got a couple of restrictions when it comes to the first party special needs trust. The most important point on the first party trust, and it goes to that second main difference that I mentioned, where does the money go when the trust beneficiary passes away? In the first party trust context, we have what's called the Medicaid payback provision, which stipulates that after the beneficiary's death, the state is reimbursed from the trust for Medicaid benefits that they paid out during the lifetime of the beneficiary. So that's important to keep in mind. Last week, as a follow-up, you may remember when we were talking about stable accounts, they also have a Medicaid payback, but it only applies from the date the stable account was opened to the present. Here, it applies from birth to the present, so a much more significant payback provision. And it's one of the main reasons why we want to try to avoid the first party special needs trust context if we can. There are some instances in which we can't, for example, personal injury accidents, but there are also contexts in which we can, for example, parents not planning ahead and their son or daughter receiving inheritances that could have been left to a third party special needs trust. And then lastly, well, a couple last points. The trust, again, exists for the sole benefit of the disabled beneficiary. Distribution should be made for them and for their benefit. And then it's designed, again, to supplement, not supplant government benefits that are being received. So switching gears to the third party special needs trust.
And
Yeah.
if you want, maybe pause and see if there are questions about first party trusts. I know I see situations where someone either receives funds or they already have funds. Families come to me and they want to pursue the Michelle P. waiver as an example, but there's a savings account or an investment account, or there are funds that the individual has that have accumulated or been received. So a first party trust can solve a lot of issues quickly by being able to sweep aside almost an unlimited amount of money and still maintain eligibility for these needs-based benefits. So there is no maximum as to how much money can be in a first-party trust. You could have $1 million first-party trust as an example. There are many out there that have that and more from large settlements. And they can be set up relatively quickly, depending upon whether it is necessary to go to court or not.
We've got a question here. It says, we've got a special needs trust set up years ago. No idea if it's first party or third party. If I look at it, will I see specific terminology basically to recognize which one? So this depends on a couple of things. One, who drafted the special needs trust. Some things to look for that will tell you one way or the other, hopefully, is the Medicaid payback language. So if it has that Medicaid payback language in it, good indicator that it's a first party special needs trust. If it doesn't have it in there, good indication that it's a third party special needs trust. Another thing to look for is funding. So look back to those two main differences. Look to see, and this likely would be near the front of the document, what assets were being placed in the trust and what source those assets were coming from, whether or not they were from a family member, parents, or whether or not they were coming from the individual with special needs. So those would be the two things that I would look for first. But I will be honest, I have seen trust done by attorneys that don't practice in this area that they've muddied the water. They've got all kinds of stuff in there, and they've kind of meshed both types together. And unfortunately, you can't not do that. So hopefully that's not the case here. But those should be the first two things that you look for.
I think part of the description of this evening was commonly made mistakes. And this issue of what type of trust do I have, especially with trusts that were done years ago in the early years. There was a little less definition between first and third party. Like anything, we've all gotten better at this. But I would suggest if you're planning, your existing planning is more than 10 years old, even if you just feel confident all the I's and the T's are dotted, I would really encourage you to sign up for a consultation and have your existing documents reviewed, because you don't want to find out after the fact, that there was a problem. These issues are so easily resolved up front or ahead of an event such as a death or something. And it's really good to take a look, especially if you planned some years ago. There are also some situations where people have planned prior to 1993, prior to when we use special needs trusts. And even if a trust is funded already, meaning someone died and a trust was funded, there are often ways to remedy an existing situation. Without going into a lot of detail, in my 20 plus years of experience with special needs, almost everything is fixable. Almost everything is fixable. And so regardless of what you hear during these sessions, do not be discouraged, because if there's something you hear and either you're not sure or you think maybe you're on the wrong side of things, practically everything is fixable. The key is being proactive and not waiting until after an event or something like that. So I just want everyone to be encouraged. Let's see here. Okay.
There's another question kind of to that point. If it's wrong and you say the first can't be taken back, what do you do? Again, to that point, there are steps that we can take to alleviate those issues if there are any issues. So there are steps that we can take, even if there's something wrong, quote unquote, with the existing trust. So again, don't be discouraged. Come talk to us and we'll figure it out.
Okay.
Any other questions so far on first party special needs trust before we switch gears to third party? Okay, seeing none. So moving to the third party special needs trust, this is the more ideal context for parents when we're thinking about planning for the future of children with special needs. So keep that in mind. So these types of trust depend upon state law. The trust can be set up and funded by anyone. So going back to that first main difference, who sets up the trust, whose money funds the trust. In this case, it's anyone other than the individual with special needs. So it can be parents or other family members such as grandparents. Those are the common sources of funding for these types of trusts. Later on, Gordon will talk in more detail on funding special needs trust and what mechanisms we can use to fund the trust. The beneficiary and the grantor or the settlor, that's just the person that establishes the trust, can be any age. The only caveat there is that the grantor has to be at least 18. So they have to be an adult to set up the trust. So the grantor can either set up the trust as a revocable or irrevocable trust. What that means is we talked about in the first party context where it has to be irrevocable. It can't be taken back. Revocable trust is just the opposite. So you could set it up during the grantor's lifetime or until the trust is funded by someone else. It could be revocable where they could theoretically take the trust back. In most situations, The third party trust would be a standalone special needs trust, meaning it's its own standalone trust document. And it can be funded at any time, either during the grantor's lifetime or upon their death. And then you can also have a testamentary third party special needs trust, which is created in your will um, to be funded upon your death. I don't recommend that. In my experience, that causes a few more issues. And when you balance the benefits and the negatives, I think the negatives outweigh the benefits of the testamentary trust. I think it's better to have the standalone special needs trust. Um, and then the main benefit of the third party special needs trust, going to that second point, where does the trust funds go upon the beneficiary's death? At the beneficiary's death, there is no payback requirement. So in the third party context, the trust assets are going to go wherever the grantor, typically that's mom and dad, wherever they say. So if they had 3 children, one had special needs, 2 did not. A common arrangement would be for them to stipulate that the remaining trust funds are split equally among the other 2 non-special needs children. You certainly don't have to do that, but that's a common example. And it underlies the real benefit of the third party context planning ahead is that you get to keep the money in the family rather than exposing it to the Medicaid payback. So that's the real main takeaway there. And the trust, again, is designed to supplement the benefits that the beneficiary is receiving. So it's not designed to provide for those basic food and shelter expenses unless there's a need greater than what the benefits are providing. So, for example, if the individual is receiving SSI, that's for food and shelter expenses, the maximum benefit is $794 a month. If that individual has $1,000 in monthly food and shelter expenses, obviously $1,000 is more than $794. So that extra $206 need can be covered by the special needs trust. And again, that would be an example where it's supplementing the benefits. It's not supplanting what the individual is already receiving. And then pooled special needs trust. So as we mentioned, the pooled special needs trust can either be first party or third party, depending on the master trust agreement, which we're going to talk about in a second. So these arise in a situation where there's one master trust agreement that governs several small trust accounts. The small trusts are pooled, the small trust assets are pooled for investment purposes so that you can increase your earnings potential. But otherwise, the small trusts are held and administered separately. So, an example, typically organized by a nonprofit in Kentucky, Life Plan of Kentucky is one of the main nonprofits that can administer pooled special needs trusts. Again, the assets are pooled for investment purposes, but the assets are deposited and the accounts are administered for each different small trust, and they're accounted for separately. So they're only pooled for that investment purpose. And then upon the death of the trust beneficiary, the individual with special needs, depending on the trust document, will decide where the trust assets go. So they could go to the nonprofit potentially, they could go to reimburse Medicaid, or they could go to family members, kind of like the third party special needs trust context. Again, it depends on what the trust document says. So if you end up going the pooled trust route, it's important beforehand to really read that master trust agreement to understand how this money is going to be distributed when the individual with special needs passes away. So in this context, the pooled trust serves as the trust itself, and the nonprofit serves as the trustee, which Gordon is going to touch on again in more detail later. This type of trust, the pooled trust, can be a less expensive option, and it can work in cases where there aren't enough resources available to fund a standalone special needs trust, or if parents aren't able to come up with a viable trustee option, this could be another case where the pooled special needs trust comes into play. And then finally, kind of switching gears a bit, but talking about the trustee's role and the connection that the trustee has with other important roles within the special needs planning context. So the trustee, again, manages the trust. They're in charge of the trust administration, the record keeping of the trust, distributions from the trust, filing any tax returns for the trust. Most times, the trustee is also a family member. And in some contexts, they're also serving as potentially the individual's guardian or the individual's power of attorney. So they also may have decision-making authority over the individual's finances, medical decisions, day-to-day personal decision-making. So they could really be serving many different roles. So sometimes the lines between these different roles can be blurred, especially if the same person is serving in many different roles. But it's important to note family member, again, generally, they can give input to the trustee on recommendations in terms of how the trust could be used for the benefit of the individual. But if they're not serving as the trustee is going to have, at the end of the day, the decision-making authority on how the trust is used. If it's the same person, again, decision-making is going to lie with one person. So just remember that one person could potentially serve in all of these roles. And in many cases, it's one or two people that are. And it's just sometimes the distinctions between these roles can be a little bit muddy. So Gordon, I think, is now going to switch gears, and we're going to talk about funding special needs trust in a little bit more detail. So Gordon.
Okay. Any additional questions on the types of trusts? Matt did a great job of walking through the first party trusts, primarily funded by an individual's own money or settlement they receive, an inheritance they receive, et cetera, but the funds are attached to the individual with special needs. Third party, where anybody else's money is welcome and there's no Medicaid payback. Pool trusts. Any questions about these different trust vehicles? It's great that we have different options so that we match the situation with the best vehicle possible.
And Gordon, one thing to kind of tie in last week as well, with a stable account, oftentimes the best situation is to have a stable account and a special needs trust in place, and they're working together. So that's another way, if you meet, we can also discuss that in more detail and how
Right.
that is beneficial.
Yeah, Matt brings up a good point, and it's sometimes it's not a trust, special needs trust versus an ABLE account, but they can work in tandem. An example would be a stable account can be a great substitute for a first party trust if you're under the limit, $15,000 a year unless they have earned income, which makes the limit a little higher. So that family whose child is targeted for the Michelle P, but they've got $10,000 in a savings account, an ABLE account to the rescue in that situation. So first party trusts have evolved into trusts for dealing with larger situations. That is ones where the ABLE account just does not have the capacity. The other thing to keep in mind is not only is there a $15,000 annual max, but if SSI is involved, you have the $100,000 max with ABLE accounts. So again, ABLE accounts are great when it's a little too much money to just go and spend, go on a shopping spree or prepay final expenses, but it's under that $15,000 limit. Get north of $15,000, you are likely looking at a first party special needs trust.
Yeah, and Gordon, connecting another dot to your example where the individual had $10,000, one of the benefits of doing the stable account as opposed to the first party special needs trust comes into play with that Medicaid payback as well, because again, Medicaid payback for the stable account is only going to apply from the date the account was opened and then forward, whereas the first party special needs trust brings in all of the prior years from birth. So that could be
Yeah,
another advantage.
sure. Best thing to do with a stable account, though, is spend it. I mean, get money in there and figure out how you're going to spend it. Have a little
Yeah.
fun, you know. Don't hoard money in a stable account. Let it accumulate into tens of thousands of dollars. It really does. I call it a put and take or save and spend. And I think we all know what those types of things are about. You save it up, you take the vacation, you go on the cruise. That is when we're traveling again. You know, and so forth. But it is just it's wonderful strategies that are available to us these days. Okay, so methods for funding a third party special needs trust. So lump sum means somebody has a checkbook. So we've got 1,000 or 5,000 or $10,000. I'm often asked, you know, what do you have to fund a special needs trust? And I mean, I have literally set up trust accounts for $1,000 or $500. You do not have to have a large sum of money to fund a special needs trust. And so we can set up a trust account with a modest amount, and then it can be added to annually, as you see there. It can also be added to monthly. So if there's a little extra every month, let's say $50 a month, then we could set up a trust account where $50 a month is electronically drafted in. I have a family in the Kentuckiana area where usually once a month religiously, they have $500. So what happens is SSI is coming in, the parents are reimbursed for food and shelter expense, and that gives the parents a little extra money at the end of the month. And so they choose to transfer money monthly into the special needs trust. And I'll tell you, you'd just be surprised. It's almost like saving for education or retirement. You know, started with 1,000 and 500 here and 1,000 there and that type of thing. And before you know it, it's 12,000. It's 18,000. It's like that 401k. It's like, wow, like yesterday I only had 1,000 or two, and now it's up to 12 or 14. And what's exciting, of course, is that by investing the funds, not having them sit there like a bump on a log earning nothing, but having them invested, and we use carefully constructed, diversified, moderate risk, balanced growth and income portfolios. So we are not talking about excessive risk. And you can reach a point where, shoot, the trust is growing as much by the capital gains and interest and dividends as it is by what you're putting into it. And then over the years, it just, it balloons. So really exciting to see those situations. And being an advocate for the trust beneficiary, I'm always looking for ways to help people fund these trusts better because it's a happy day when there's ample funds in the trust to pay for what the beneficiary wants or needs. And it's frankly kind of a sad day as the trust starts to winnow down and does not have sufficient resources to meet many of the needs of the trust beneficiary. So, oh well. So again, lump sum, annual, monthly, periodic. Also, I should mention that funding can come from a variety of sources. I know one trust comes to mind, a family in the Lexington area, and we have on a monthly basis, we have money coming in from both sets of grandparents, from both of the divorced parents, and from a godparent. So we literally have electronic arrangements set up where we have money coming from 5 different accounts every month. And it's, I think most cases, it's only $50 a month for each, but add that up, that's $250 a month. That's $3,000 on the year. 2 or 3 years later, you hit 10,000 and you keep climbing. And again, like I said, it doesn't take that much, but over time, it's remarkable how the funds can accumulate. So do not think as parents, we don't have, we do well to pay our bills. There's not that much because again, grandparents, godparents, aunts, uncles, other family members, close friends can get involved. We have, and
I want to know like how I work for you, so I know the answer to this, but oh, and there's my little man. Oh, here he comes. How do you have that conversation? That's a hard conversation to have. And I've yet to have it with one set of grandparents. And so I know you talk about this during the personal consultation, but I think it would be great if you could share with everyone, how do you have that conversation about giving to the trust or maybe a stable account?
Well, I think part of it is the dynamic of the relationship with the respective person you're talking to. But as a part of our process, we do provide a letter that can be snail mailed or emailed that basically announces that the trust exists. And that's a great starting point because that starts the conversation. Here's this trust. And, it doesn't have to be a heavy handed, fundraising letter, as I sometimes lovingly and laughingly say. It doesn't have to be like the mission trip letter, send money preferably in increments of 100. We will send photos, it could be a very light touch, but and then sometimes one grandparent talks to another, and the positive action one takes spawns others that get involved, etc. So really, really super how that works. And these days, as we've discussed before, monies can be rolled over or transferred. So if there's monies in a 529 that may not be used for higher education, oftentimes we can look at transferring those into an ABLE account. And then again, if one is doing well enough to where maybe Social Security creates some excess funds for the parents, money again can be put into the trust systematically. There's just lots of ways to be creative. Also, if your child with special needs gets a part-time job, then the extent to which they're paying their way, so to speak, you may have a situation where you can have them pay for transportation that you're providing to help pay a part of a cell phone bill or cable or Netflix or these types of things. And so you can look for ways for them, in essence, to reimburse you for expenses that you're incurring. And once you've been reimbursed, the same as SSI, you can place those funds in a third-party special needs trust account where there's no Medicaid payback, and where those funds can ultimately help preserve the quality of life for your loved one with special needs, and then become a legacy to their siblings or future generations. So very, very cool. Life insurance via a beneficiary. This is really positive because, again, many people simply hope they don't run out of money before God calls them home. And so they really don't see in the end game there being excess money to fund a trust with. So life insurance can be existing life insurance or new life insurance secured, can be set up in such a way that the trust either owns the life insurance and pays the premium, or is the beneficiary of life insurance. And here we're generally talking about life insurance on a parent or grandparent, that type of thing. In rare instances where the individual with special needs is insurable, it can involve life insurance on them, but the primary goal is to ensure someone who wants, upon their death or passing, a benefit to go to fund the trust, so that there are resources to help preserve the quality of life. So we deal with these beneficiary issues all the time, and it's life insurance. And then in addition, it is retirement funds as well, such as 401k, 403b, 457 plans, your Simples, your SEPs, your IRAs, your Roths, and the list goes on and on. And so it's possible to leave some of those funds. And today I was asked a question by somebody, a very appropriate question, and that was, is it all or nothing? If I list a trust, does it have to be 100%? And the answer is absolutely not. You can be fair and equitable among all of your children. You can leave so much to a spouse and carve out a percent for the special needs trust for your child. So we deal with multiple beneficiaries all the time, making a provision for all of those that you love. So it's definitely not an all or nothing. Investment accounts via transfer on death. Let's say that you have an investment account, maybe some stock or some mutual funds, that type of thing. Maybe you even inherited it. Maybe you had a bonus and decided to buy a mutual fund or something. It's possible to put directions on those accounts so that when something happens to you, it's scattered to the various beneficiaries that you wish to receive those funds. So again, that can be 50-50 among two or thirds or fourths or however you want to do that. So there are ways to get life insurance, retirement funds, investment accounts, and even bank accounts. Usually we're looking at CDs with this as payable on death directions, so that when something happens to the CD holder, then what's left in the CD can go to the trust. Also
Or
property.
we have a question in the chat.
Okay, thank you. I appreciate
Do
that.
you want to tackle it or?
Okay, so, it looks like a good one here. Okay, how do we list our child's trust on a beneficiary change form for life insurance and 401k? It asks for name, address. Do we just put the John Doe trust and put our personal address? Well, great question. And in the work that we do with families, we very much take a hands-on approach at working with these beneficiaries. So frankly, we oftentimes are helping literally fill out these forms because they're oftentimes not user-friendly. And so it's a matter of getting creative as to how the pieces of information that you're attempting to communicate can be plugged into a form that seems not user-friendly. So yes, sometimes it's putting the trust where the name goes. Sometimes it's putting the date of the trust where the date of birth would otherwise go, the address of the trustees for an address. Sometimes they ask for a tax ID number. Sometimes we've secured one, sometimes we've not. So we help families with this. And believe me, as I often tell families, help with updating these beneficiaries is a really good thing. Getting some help with this. So great question, and we can help. But the bottom line is, yes, it can be done. Help is simply a good thing. Great question. Thank you. Okay. Let me come back to here. Boom. And there we go. Boom. Yep. All right. So third-party special needs trust continuing lump sum payments as an example. So caregivers or others contribute lump sum payments to the trust. Can be a small amount, like we said, 500 or 1,000. It can be several thousand, that type of thing. So lump sums can be made, also appreciated investments, etc. Okay. And then annual or monthly contributions can be made. These can be done either upon request of the person wanting to give the monies, or it can be set up on a systematic basis where electronically funds go in, almost like the special needs trust is a bill you pay with so much going into it automatically each month or quarterly, etc. And we set all that up. We try to make things as automated as possible. People love things that are automated where they're just not as labor intensive. Okay, life insurance, caregiver or others pay premiums to the insurance company for the insurance. And then upon someone's death, the life insurance benefit is delivered to the special needs trust, typically tax-free. That is one of the advantages of life insurance. Not only does it leverage small premium dollars into a large benefit to fund the trust, but in addition to that, the benefit to the trust is tax-free. So there's no tax consequences to the estate of the person that died. Typically, there's no tax consequences to the trust that's receiving the death benefit, etc. And it can be divided up among numerous beneficiaries, whatever works for the person who owns the policy. Okay, just to talk briefly, and we're right on time. We're doing great. Different types of life insurance. So there's term, there's universal life, permanent life, and second to die. So term, we're most familiar with group covers through work, my group term life insurance, or a term policy perhaps that you pick up maybe that lasts for 20 years, etc. There's universal life, which we frequently call permanent term. Really does not, it's not used for accumulating funds, but it's used to make sure that life insurance lasts as long as you do. Then there's permanent coverage, often thought of as like whole life, that type of thing. And second to die. Second to die is a special type of coverage that we use a lot in special needs planning in two-parent situations. It's a single coverage that insures two individuals, so one policy, two insureds, and it guarantees a benefit to fund the trust upon the death of the second insured. So in a two-parent situation, it guarantees the special needs trust gets funded when the second parent dies and there's no longer a parental advocate. That's usually the point at which siblings or other family members are stepping up. And that's the point where the parents are just usually so very concerned about making sure the trust is well funded. As we talked about in a prior session, there are four things that you want to keep in mind that family wants to know is in place when it comes to special needs planning. One is they're very interested that the government benefits continue. And of course, our planning has everything to do with preserving eligibility for Medicaid, waivers, Social Security, et cetera. Second, they want to know that there's a resource to turn to pay for what the government can't or won't. Because even under the best of circumstances, the government does not cover everything. As as Matt was saying earlier, primarily food, shelter, and healthcare. So it's what's going to cover the rest, and that's a well-funded special needs trust. Third, they want to know that there's an owner's manual, as we call it, a letter of intent, a caregiver guide with all the details of routines and schedules and all things that are involved in their life. And we have a template for that. We help families build that. It is a labor of love, and what a gift to a future guardian or caregiver. And fourth, they want to know they're not alone, that there is a group of people, caregivers and case managers and physicians and on it goes, that are going to support their efforts to help take care of your loved one with special needs. So really important stuff. The trust can be, by what Matt was saying earlier, if it's a standalone trust, it can be funded now, meaning it can be an active participant in their quality of life today. And then of course it be there in the future. Okay, the tax-free nature of life insurance, very powerful. Okay, let's see here. Matt, I think, oh, well, I got a couple more, don't I? Yeah, okay, thanks. Okay, a lot of slides in this presentation, so bear with us, we're getting through them. Okay, over 93 also brought about the Miller or qualified income trusts. And frankly, the Miller Trust has historically, post OBRA 93, most often has been looked at as a vehicle to deal with income issues for the elderly when someone was going into a nursing home, meaning there's too much income. So how do we preserve income and not have it simply go toward like a nursing home bill, et cetera, so that it can be there for extras and to help preserve quality of life? Well, like so many things in special needs, we hijacked it, to excuse the expression. But we said, well, if it can work for them, it can work for our children that have special needs. And so, as you can see here, it's an irrevocable trust set up to receive monthly income in excess of the $2,382 allowed to maintain, and that's per month, allowed to maintain disability, Medicaid, and waiver services. So you might think $2,382 a month, oh my gosh, we're nowhere near that. How could it possibly apply to our situation? So here are a couple of examples, since this is kind of cutting edge and newer stuff that we're working with. So example one, Daniel has special needs and is employed earning $1,000 a month. So maybe he has a part-time job at UPS, because they do employ individuals with developmental or intellectual disabilities there, or maybe at Lowe's or even fast food or something. But he does his 20 hours a week or what, just part-time, and he's earning about $1,000 a month. He receives $458 of SSDI, that is Social Security disability income, off of his own record. Because he's earned $1,000 a month, he has qualified for Social Security disability, and he's receiving $458 a month. He's also getting $336 of SSI. Of course, SSI is a reduced benefit amount because of his other income, but nevertheless, he receives that for a total monthly income of $1,794. Earned income is under the substantial gainful activity limit of $1,310, and total income is under $2,382. If he stays under $2,000 in resources, all is good. What I mean is, believe it or not, he can have Medicaid, Medicaid waiver services, SSI, SSDI, employment, Medicare. He can have it all. It's amazing. However, a wrinkle in time here, and in 2021, his dad retires, making Daniel eligible for adult child benefits, meaning he can draw off of his father. His total SSDI benefit now increases from what was $458 to $1,500. He's no longer eligible for SSI, of course, with getting $1,500 a month in Social Security disability. So his total income goes to $2,500, $1,000 a month from his earnings, $1,500 a month from Social Security disability, exceeding the $2,382. Now he's in trouble. He's over by $108 a month. The $2,382 is the maximum. We talked about this in the first session, but $2,382 is the maximum for disability Medicaid. And therefore, you have to stay under that, or you lose your Medicaid and you lose your waiver, like the Michelle P. So he's over by 108, does not want to lose his Medicaid because he doesn't get health insurance with his part-time job. He's got to have his Medicaid. So this could result in a loss of Medicaid and waiver. A Miller Trust is set up to receive any monthly excess over the $2,382. So believe it or not, a Miller Trust could be set up. The $108 a month swept over into the Miller Trust. He's now under the $2,382. He keeps all of his benefits. And that $108 a month can be his vacation club, because anything that enhances his quality of life, if used for his personal benefit, can be paid for from that Miller Trust. So that's one example. Example two, Ted has special needs and both parents die in an auto accident. He works part-time and earns $700 per month. Maybe he's just working 12 hours a week. His adult child survivor benefit because of loss of both parents is $1,800 a month. Well, of course, look at the math, 1,800 and 700. He's at the same 2,500 that Daniel is in the first example. A like solution with a Miller account can keep him on all his benefits. Okay, questions on Miller accounts, Miller trusts, Miller, or otherwise known as qualified income trusts.
Gordon, we've got a question in the chat box.
Okay,
I don't know.
let's see here. Thank you. Appreciate that. Okay. Can there be a third-party trust, then use a Miller trust if needed, or could excess monthly income go into the third-party trust? Wow, great question. I'm not surprised with who it came from. Okay, so the answer is you can have as many special needs trusts as is appropriate for your situation. And I'm so glad this was brought up, because we made a point in talking about stable accounts that you can have how many? One. But you're not limited to a single special needs trust. In fact, each set of grandparents can set up their own special needs trust for the grandchild. Parents can yet have a third-party special needs trust. A godparent could set up a fourth. There is no limit as to the number of special needs trusts that can be in place. And they can also, a person can literally have all three types. A person could simultaneously have a first party that they put an inheritance into that they received that didn't go to a third party trust, or a settlement. They can have a third party trust, funded or unfunded, that the parents or other parties are going to put money into, and they can have a Miller trust to deal with income. Now, please keep in mind that a Miller trust is to resolve an income situation. It's not to resolve a resource situation. Your first party trust and your able accounts or stable accounts are to resolve resource situations as a general rule. So it's figuring out, back to what Matt said, if you're starting to get a headache, we're almost done. And if the thought crossed your mind that, oh my, SSI, SSDI, Medicaid, Medicare, and all these different types of special needs trusts, this is complicated. You're absolutely right. And 23 years ago, when I began my personal special needs journey and decided to focus my practice in this area frankly, I thought, well, I'm a quick study. I'll pick this up in no time. And I have to tell you, 23 years later, I'm still learning. It is very complicated and the rules and regulations change. And so back to what Matt was saying, it really is so very important to work with people that do this on a daily basis, despite their best of intentions to be helpful. You really want to get it right. And when you get it right, there is much to celebrate, much to be excited for. So thank you so much for that question. Yes, you can have both a Miller Trust for dealing with income, a first party trust dealing with assets or resources, and even a third party trust. And the other thing I want to mention is that as these become more mainstream, about like so many other things that become more common. Anybody remember what we paid for our first desktop computer, tower and monitor and so forth? I mean, it was over $3,000. It was incredible. You know, the first microwave we bought. I mean, if you bought a microwave, a Carousel brand, your neighbors came over to watch food go around on the glass turntable, and you probably spent close to $1,000. So special needs trusts have become far more reasonable and accessible to people regardless of their financial circumstances. So again, just because it's complicated, I don't want you to think it's beyond your reach. We're here to help everyone. Okay.
Gordon, I just want to put a last point on that last question. The excess, just to clarify, the excess monthly income going into the third party trust. So again, the Miller Trust often comes up to address income issues that arise in the context of the individual with special needs having too much income. If that's the case, their income, again, can't go into that third party special needs trust.
Oh, yes.
Again,
Right.
that's designed only for third party money. Mom, dad, grandma, grandpa.
Yep.
The individual with special needs cannot put money in the third party trust. So just wanted to clarify that.
Yep.
So
Yep. And the reason is because a Miller Trust, we did not list it, but a Miller Trust has the Medicaid payback the same as the first party trust. So the consumer's money can't go money or income cannot go into a third party trust. However, if, as I mentioned earlier, there are things that parents are providing for them that they could be reimbursed for. So as these numbers start to become a bit larger, it may just get just a little more expensive for your youngster to live on your estate, if you catch my drift. Because you really want to convert their money to your money so that you can place it into a third party trust. But what's the point about talking about Miller Trusts? The point is that I want you to embrace potential employment for your special needs, a child or family member. There's a way. Do not worry about the income issues. We will work through it. I should also mention that please understand, a Miller Trust does not solve earned income exceeding the SGA limit of $1,310. So this is a booger, let me tell you, right here. There's no easy solution for earned income in excess of $1,310 a month or the SGA limit. That's one you really have to watch, because if they're going to plunge ahead of that, it needs to be to 40 hours a week earning a full salary with benefits, because they're going to be giving up a lot to consistently exceed $1,310 per month in earned income. Okay, we're getting close on time. Let's see, I am, okay, we're about ready to turn it over to Matt. So again, sources: Social Security, Medicaid, Medicare, government benefits on the left. So the government's providing the basic subsistence of needs, and then to the right, the special needs trust, call it for the fun stuff: gifts on special occasions, professional fees, dental care, not so fun, vacations, trip, entertainment, education and other services. Basic care of social benefits are cut back if waivers get cut. Let's say the Medicaid or the Michelle P budget gets cut from 40,000 to 35 or something, and they need more, then again, the trust can supplement. All right. Okay, so trustee options, it can be a family member, such as parents, often trustees. You can have an attorney service trustee. You can have a corporate trustee, such as the Mass Mutual Trust Company. So if you can't immediately think of a family member beyond you that you want to serve, don't worry. We'll help you. We'll help you figure it out. We'll find a way. This just goes through a little bit of what their activities are, managing the money. They do not have to have an MBA. I manage lots of trust assets for trustees. And then we make referrals to CPAs to handle taxes. And being a trustee isn't so bad if you don't have to deal with the investments and you don't have to deal with the taxes, you know? So we try to take the burden off of the trustees for their willingness to serve and make it as easy as possible. Okay, 3-step process of setting up a special needs trust. And I think, Matt, you're up.
Yep. So just practically speaking, what does this process look like in terms of setting up a special needs trust? So step 1 is really all about gathering information. So this could be gathering information regarding the trust beneficiary, again, what they own, if they own anything, what sources of income, if they're working, etc. Information on the potential trustees, on the grantor, remainder beneficiaries, and also information on funding sources, when the timing, when the trust is going to be funded, whether during life or after death. So gathering information, and then once all that's assembled into the trust document, it'll be assembled into a draft, and then you'll take that draft. You also have a list of the assets that are potentially going to go into the trust. So you've got all the information. So then you go to step 2, which is really the review process. So if it's a parent or family member serving as the trustee, basically what that entails is they sit down, they read the document, and they have any questions answered. If it's a professional trustee or a company serving as trustee, such as a bank, then the draft will need to be sent to them so that they can review to make sure that it meets their requirements. Some organizations require certain things from trusts before they will accept the role as trustee. So you have to clear that. And again, that would involve the attorney communicating with the organization and passing the trust document along to them, and then addressing any questions that they have. So that's the step 2, the review process. And then step 3 is the signing process. So once if it's a parent or a family member serving as trustee, that just means they come in and sign the document after they've reviewed it and had any questions answered. If it's an organization or professional trustee, you may have to sign some additional documents for their purposes related to them serving as trustee. But essentially, gathering information, reviewing the documents or the documentation, and then step 3, signing everything, and then that's basically it. Gordon, we do have another question in the chat box.
Okay, and we're right on time for finishing. We only have about 2 slides left, 2 or 3, about 3 slides left. My son could reasonably make more money, so the only income option would be the Miller Trust, correct? Not the stable account. Could you restate the resource versus income options? Okay, so yeah, so there are some circumstances where we make focused decisions on what government benefits we're going to preserve and what government benefits we're going to let go of. And every situation is, is different. Also, there are cases where we work to hang on to Medicaid and the waiver, and we let Social Security, disability, and Medicare go. And that's possible. That's possible also. That is, if we're going to exceed the $1,310 substantial gainful activity level, that may mean letting Social Security, disability, and Medicare go, but through using the Miller Trust, one could still hang on to their Medicaid and their Medicaid waiver services. So great question. Every situation is different. Yeah. So role of a financial professional, looking at the needs and then putting together the right strategies to preserve what benefits are important, making the most of the different trust options, as well as assets that are given over to fund the trust. Making sure we don't unintentionally put benefits at risk. As I said, sometimes decisions are made about what benefits to retain or not, and know the questions to ask about current and future needs. Help the caregiver maintain the lifestyle of their loved one with special needs. So at MassMutual, with our special care and special care planners, we seek to help. I know that I enjoy very much teaming with Matt to address both the legal and the financial and government benefit issues together, working together. Look for your email tomorrow with information about next week, and also a reminder about your free follow-up consultation. And I really feel excited about the information we covered this evening. I know it was a lot, but we purposefully wanted to deliver something more than you might have read in an article or heard in a brief workshop. Rare do we have up to 90 minutes to focus on special needs trust and dig just a little deeper. So we're hopeful that's been helpful. Take advantage of the free consultation for additional questions or how all this information applies to you and your situation. 1 week from tonight, 6:30 as usual, it's going to be life care planning. We will be, it's actually a new workshop. Matt and I were just looking at it at breakfast not more than a month ago, and it will be the first time I deliver it. So you're going to see it for the very first time, and it's head and shoulders above of what we had previously. I remember looking at it for the first time with Matt sitting at breakfast. And I was like, wow, this is really good. So that'll be next week. And so feel free to go back over your notes from the last several sessions, bring questions from any of the 4 sessions to our workshop next week. And again, it's life care planning as we seek to look into the future and pull all of the various elements that we've been covering in these Tuesday nights together. Matt, I'm sure you join me in thanking everyone for participating. Another great evening. We really appreciate it. Matt, anything?
Yeah, just thank you guys again for being with us. Hopefully you'll be with us next week. Again, the goal next week is to put all of these topics together so that you can start to connect the dots and see how all of this works together. That's the whole reason why we did the series this way. So hopefully you'll be with us next week.